Hi, good afternoon, and thank you for joining us in session two of the webinar on the future of arbitration in India. I think we had a really interesting session in the beginning of the webinar, and we heard important perspectives from Justice Gupta on strengthening India's arbitration ecosystem and his emphasis on the role of institutional arbitration in this evolving landscape. In this session, we move to the practitioner's vantage point, focusing on how institutional arbitration and mediation are functioning in practice and how they're shaping the future of dispute resolution in India. It is my pleasure to introduce Mr. J Jawad, Registrar of the International Arbitration and Mediation Center, Hyderabad. Mr. Jawad brings over 3 decades of experience as an advocate. And for nearly 2 decades, he has been deeply involved in mediation training and ADR capacity building across India, which is very key, as we will also explore during the session. He has served as a senior mediator trainer with the Supreme Court's Mediation and Conciliation Project Committee and with the Tamil Nadu Mediation and Conciliation Center under the High Court of Madras. He has trained judges and practitioners at institutions including the National Judicial Academy in Bhopal and the Tamil Nadu Judicial Academy. He is also global faculty with ADR ODR International in the UK, and he has worked extensively in cross-border dispute resolution initiatives. And we might all have read his work as he's contributed to leading publications on mediation practice as well. Mr. Jawad, it is a pleasure to have you today. In our conversation during this session, we will touch on a few themes, including evolution of disputes coming before institutions, practical challenges in the adoption of institutional arbitration, the role of mediation in dispute resolution, and broader cultural shifts in ADR. We will then leave some time towards the end, probably after 40 minutes, to take up a few questions from the audience as well. So, Mr. Jawad, from your position today as a registrar at IAMC, what shifts are you noticing in the kinds of disputes that are coming before institutional forums? It can be in the form of sectors, complexity, or just the expectations of parties in the process.
Aishwarya, I think there is a gradual shift that is happening in India today because there is a growing awareness of the advantages of institutional ADR. I'm calling it consciously ADR and not just arbitration because I sincerely believe that it should be a mix of both mediation and arbitration, especially where we are talking about high-stake commercial disputes. So we are seeing a gradual shift where institutions have also come up. Just as Hemant Gupta pointed out earlier, that there were no institutions worth the name earlier, but today that situation is changing. So we have the IAMC in Hyderabad, we have the MCIA in Bombay, we have, for example, IIAC in Delhi. So these are all institutions that are developing on par with any global institution. So when we talk about this institutional ADR, we are talking about real institutions that are there, which not only have the infrastructure in terms of a very professional setting for the conduct of mediations and arbitrations, but also in terms of the technological support, the case management support, and all the other factors that go into making institutional ADR as the choice for people who want to resolve the disputes in a very quick way. So we are talking about streamlined rules. We are talking about very clear-cut dispute resolution clauses. We are talking about professional case managers. We are talking about online case management platforms. Just yesterday, IAMC signed an MOU with JustAct, and the MOU is a very broad-based MOU where we have discussed. We are going to be talking about a lot of collaborations in the future in terms of creating awareness among various stakeholders of the advantages of institutional and online dispute resolution. We are also implementing the JustAct case management platform in the IAMC for managing both our mediations and the arbitrations. So we see a perceptible shift that is happening today. And that shift is going to go a long way in making India and a global hub for mediation and arbitration. But what we are lacking today is actually a clear-cut policy framework in terms of, how are we going to go about it? And what is the policy that is going to be adopted where dispute resolution is concerned? Because we have this, because of our common law obsession, we are, mixing justice delivery with dispute resolution. Because justice delivery is a different paradigm. It needs a different paradigm, and dispute resolution needs a different paradigm. Dispute resolution operates more on a problem solving, collaborative problem solving paradigm. And that is where the institutions, credible institutions, because one of the risks that can happen if there is no proper policy on the ground is that we will see the cropping up of a lot of fly-by-night operators who will, set up these institutions and will not have clear-cut rules. They will not have the proper infrastructure, and that will bring a bad name for the Indian dispute resolution ecosystem itself. So that is something we need to be very careful about, and that is where I think we need to have a clear-cut policy framework first, which the government, the judiciary, the various stakeholders, the chambers of commerce all have to sit together and brainstorm. We already have the recommendations of Justice B.N. Sri Krishna's high-level committee report, which can be used as a guideline for us to frame the policy on what we are going to be doing for the future. And the next thing we require is, of course, the implementation of the legislations that are already there, the amendments that are already there. We need to implement that. For example, the Mediation Act, the various amendments that have been brought about under the 2019 amendments to the Arbitration Act, the formation of the Mediation and the Arbitration Council of India. So all these need to be done simultaneously to really make this work. So when parties come to institutions, they come with the expectation that the cases will be managed in a professional manner. So that is one of the foremost expectations. And also the clarity of the rules, the clarity of the processes or the procedures that are going to be followed. Okay, the clarity on the fees that are going to be paid to the arbitrators. So these are the advantages that institutional ADR would present to the parties. And this is what they bring to the table when they come forward for this. So in the IAMC, we are having a lot of MSME disputes that get referred to us. We are also now, getting expressions of interest from various law firms which want to put IAMC clauses in their contracts. So this is what is happening today.
Thank you. I think you raised an important point about dispute resolution being broader and collaborative, and what parties expect when they come to this forum. And also the critical point that today we have a very different landscape where we actually have a lot of credible institutions, in play and readily available with that amount of clarity that the parties expect. But that naturally raises the broader question why institutional arbitration has taken time to gain traction in India. Because we've been speaking about the importance of institutional arbitration for many years now. So, from where you sit, what do you believe are the practical obstacles that prevent parties from choosing this over ad hoc arbitrations or ad hoc proceedings today?
I don't see any practical obstacles whatsoever. I only see practical advantages for people to choose institutional ADR for the simple reason, as I said earlier. Number one is the clarity of the procedures, the rules. So, for example, if you look at the IAMC rules, we have the draft clauses, the dispute resolution clauses that can be considered to be incorporated in the contracts. Now, one of the biggest risks that parties face in framing these arbitration clauses, sometimes these are pathological clauses which have no clarity about seat of arbitration, about the law that is going to be applicable, about the appointment of arbitrators. But when you have an institutional clause, there's a lot of clarity about that. The second thing is, in IAMC, we are encouraging hybrid dispute resolution clauses, in the sense that we are very strongly promoting the inclusion of mediation as a first step. Or you start the arbitration, you go for mediation, and you come back to arbitration in case there's no settlement. So what are called as med-arb and arb-med-arb clauses. So we have provided the draft, hybrid clauses that can be incorporated in the contracts. So that is one of the first advantages. The second advantage is that you have clear-cut fee rules. So any arbitrators who are appointed under our rules are bound by the fee rules that are prescribed under the rules, and the same thing applies to other institutions as well. So you know what cost you're going to be incurring in the arbitration when you come for an institutional arbitration or institutional dispute resolution. The third thing is the professional case management, because we have trained case managers who handle the case from the beginning to the end. There is a virtual hand-holding throughout the process for both the parties and the lawyers and the arbitrators. We have trained tribunal secretaries who can be engaged to assist the arbitrators in conducting the arbitrations. Of course, all this comes at a little bit of an extra cost, but when you compare the cost with going to a hotel, five-star hotel, and booking a conference room there, it is substantially lesser than that, what you will be incurring if you engage an institution, if you have an institutional pass. The fourth thing is the infrastructure. We have well-appointed arbitration halls. We have well-appointed mediation halls, which have been very thoughtfully designed to provide the correct kind of atmosphere for conducting the arbitrations in a professional way. So you have a very professional atmosphere prevailing throughout the process at very, very reasonable rates. So, and we have the technology to back up whatever requires to be done. So, for example, for online dispute resolution, we have separate dedicated rooms for that, with all the virtual platforms that can help you to conduct the arbitration in a seamless way, or the mediation in a seamless way. So these are all the advantages of coming to institutions. The only obstacle that I see is perhaps the mindset. The mindset, the lack of a clear-cut policy, and well, I wouldn't like to go there, but perhaps there are reasons which I don't want to mention here, perhaps, which motivate people not to choose institutional arbitration, because one in ad hoc arbitration, perhaps the returns are much higher, and there is what you say as money can be done. Okay, so these might be the obstacles that prevent people from choosing institutional arbitration. But on a very serious note, if supposing we are to be taken seriously, and that is something that Justice Hemant Gupta also pointed out in his book, if we are to be taken seriously, I think it is important that we promote institutional ADR. And for example, if you take Singapore, the SIAC was established in 1991. And the whole ecosystem supported SIAC. So the government supported, the government funded them, the judiciary supported, the chambers of commerce supported. So all these went together to make SIAC what it is today. Now, Singapore is a small country which can have one institution. But in a country like India, every state needs at least 2 or 3 institutions to be established on the model of SIAC. And that cannot be done without the state government or without the central government support. So the central and the state government have to give the funds to support these institutions, because these institutions, you cannot expect them to start making profit and to generate enough revenue to run themselves. There has to be a support given to these institutions. Apart from that, the chambers of commerce, the stakeholders, the real stakeholders, and the lawyers will have to support this, because there are many advantages for lawyers also in this. So I think it has to be a clear-cut policy framework that needs to be evolved for this, and all the institutions need to work together. Because when you talk about India, you should be talking about an institutional framework that is identical to a single institution. So IAMC may be one institution, IAC may be one institution, MCIA may be one institution. But when you look at the rules, when you look at the panels, you should be able to see that it is one. So that alone will create the faith, because we cannot have contradictory rules. We cannot have different sets of procedures to be followed, different structures of fees that are prescribed. And most important are the panels of arbitrators and mediators. So they should be trained properly. And there's no question of, your background experience being enough for you to become an arbitrator. And sector-specific specialization. I think that's something which at IAMC we are especially focusing on. And we are training mediators and arbitrators in different sectors so that they are competent enough to mediate or arbitrate in those particular sectors.
I think so. I think two key takeaways, if I may put it that way. One is that institutions create that predictability and procedural discipline, and also the credibility. So parties can have that some amount of certainty and confidence in coming to institutions. And the second thing is, I think, important point is about all of us being in this together, because I think that's a theme also Justice Gupta raised about all of us being responsible and not working in silos, right?
Yes.
So, and you had mentioned policy, right? Maybe we delve a little deeper. Can you give more examples about what this policy could look like? Because one you said on training and sector-specific specialization, and I think also having predominantly, even though we understand these advantages in arbitration or even mediation, commercial contracts prefer or tend to have ad hoc arbitration clauses. So, what other specific takeaways or action points can we involve or adopt as policy frameworks to ensure that this traction is better?
See, one very important thing is to make it mandatory that the dispute resolution clauses should nominate one institution or the other, depending on whatever the, let's say, supposing there's a contract being entered into in Delhi, then an institution like IAAC should be nominated there. If it is in Hyderabad, in Telangana, then IAMC. So similarly, every state should have one institution at least, which will have the infrastructure and the kind of financial support that is required to, offer a proper, on par with global practices. So that's the important thing. Anything that is as good as anything that you can get perhaps in Singapore or in London or in Paris. So that's one of the most important things. The second very important thing, which we find lacking, for example, as a registrar of IMC, I see that many of our arbitrations take only on the weekends. An important question is why?
Mm.
Why does that happen? It's simply because we don't have full-time arbitration practitioners. We don't have full-time arbitrators. We don't have full-time mediators, right? It doesn't happen that way anywhere else. So dispute resolution becomes a part-time work for most of the professionals. What we need are full-time trained professionals. So that is where I think the arbitration bar, the mediation council, the arbitration council, these things have to be put in place so that we can create a pool of trained professionals who are full-time into the profession. And if you ask me, where will they get the work from? My answer is there is enough and more work. India is a huge country. We have 5.5 crore cases pending in the courts. That is because for every dispute, we use the hammer of law. But we need a more flexible, more, as I pointed out, the hybrid methods of dispute resolution, for which we need a pool of trained professionals. So the training and accreditation standards have to be on par with any global standards, which is, pitifully lacking in our country. And that is where at the IAMC, we are focusing on the proper training. And when we empanel our arbitrators and mediators, except those who come with a rich background of experience, all others have to go through qualifying assessment programs, or they have to go through our own training programs. And it is mandatory for them to go through compulsory, continuous professional development programs. So minimum of 2 CPD programs they have to undertake in a year to be continued to be empaneled with us. So these are the steps that we need to take. And the most important, another important aspect is the integration of technology, because we cannot think of dispute resolution anymore without technology. COVID changed that. And when we talk about technology, we are not just talking about ODR platforms. We are talking about case management. We are talking about AI-assisted dispute resolution processes, right? How AI can be effectively used. Of course, I'm not going into the larger question as to whether AI is going to be replacing professional mediators and arbitrators. That's different. But the effective use of AI for dispute resolution to expedite the process. So how do we use all these things? And that can only be done through an institutional framework. And that's where we need institutions to be established everywhere. And these institutions need to work together. We are not competing with each other. We are not in a competition here as to whether IAMC is better or IAAC is better or MCI is better. Okay, or we are not competing. There is enough and more work. It's a wide ocean out there, right? It's like multiple trawlers can go and catch fish successfully. We can provide those dispute resolution services to all the stakeholders in a much more effective manner if we all work together. So, for example, if I conduct a training program and I empanel, let's say, Aishwarya as the mediator. Now, Aishwarya should be recognized as a mediator or as an arbitrator by IAAC also, by MCIA also. So we have these cross panels and we have a cross referral of cases. So use of venue can be a very effective way of collaborating with each other. For example, if I have an arbitration that is happening in Delhi, I would ask the parties to use the IAAC premises for the arbitration, right? So this is the kind of collaboration that we should be looking at. And that is the only way we can make a mark. Otherwise, we can keep on talking from different podiums, different dioceses, that we need to make India an institutional hub. We need to make India a dispute resolution hub. But that's all talk. What are we doing on the ground? That is the question. Okay. And that's what we are trying to change. And that change is happening.
Thank you. I think that's a very interesting perspective, again, focusing on that fact that while a country like India does need multiple institutions, given the larger, diversity of people and population we deal with, but the fact that all of them need to work as one ecosystem to actually project us forward, as a good arbitration seat and hub. Actually, on that note, why do you believe, Justice Gupta also talked about parties choosing foreign seats? Why do you believe Indian parties still choose Singapore or London? Would you believe ecosystem is one important criteria, or is there anything else that, is quietly expressed through this choice?
I think one perhaps is the absence of the institutions, which was a legitimate excuse until recently, but
Earlier.
no longer. Because now we have those institutions and we need to create more institutions. And from IAMC side, wherever I have gone, I have spoken about the need to establish these institutions. And so wherever I have gone, I have spoken about this and I have emphasized. For example, I was in Vizag recently and I met the Chambers of Commerce president there. And I said, you have to set up an institution in Vizag. And we will support you in setting up the institution. Because I don't see this as a competition. I see this as a collaboration, as I said earlier. Because that is the need of the hour today. Every state, every major city requires institutions that would deal with the ADR. So my focus is, let's first consolidate our domestic market. And, Chitra had also asked that question to Justice Hemant Gupta, and you're asking me the same question as to why parties who are having a domestic arbitration choose a seat in Singapore.
No,
Now,
that's, I think, important to understand because that
it's
shows
important to understand.
trust in the system and
Yes.
choice of parties.
Now, see, we are relatively new in this because the concept of this institutional framework started evolving effectively only after 2017. Whereas Singapore has been in this business from 1991. So obviously they have had their trials and errors. They have corrected everything and they have had external institutional support, for example, from ICC. So they have had the support. Whereas we are also trying to do the same thing. We are trying our best to set up a system. We have examples to follow. So we are looking at the systems that are being followed by global institutions, and we are trying to implement those same systems and in fact improve them, but make them better than what the others can offer and at a fraction of the cost. That's a very important factor that I think I should emphasize here, because the cost factor, if you look at, it's a fraction of what, if supposing you choose IAMC as your institutional arbitration or institutional dispute resolution supporter base, you're going to be paying a fraction of what you would be paying SIAC. That's number one. Number two is we are putting in place the systems that are required for effective case management so that you don't have to take the trouble. Now, for example, once our case management platform with JustAct comes into operation, you're going to be filing the case. Once it is registered and taken up, everything is going to happen online. Your uploading of documents, your exchange of documents, the fixing of hearings, the scheduling of hearings, everything is going to be happening online, right? So it's a completely streamlined system. Now, one of the things that Singapore does, SIAC does, is scrutiny of the awards. Now, why the scrutiny of the awards is important? It's important because when you scrutinize the award, you're able to point out to the arbitrators if there are any, one is correction of all the grammatical and other errors that may have crept in into the award. The second thing is if there is a finding, but there's no reasoning given. So the arbitrators politely asked to give the reasoning for that, right? So the chances of the awards getting set aside become very rare. So these are the advantages. So when you have these advantages in the country and when you can do it at a fraction of the cost, now why would you choose an international center? Perhaps the only reason could be that you want to have a vacation there and you want to have a foreign trip there. But that's in a lighter vein. I'm not saying that's the sole reason. But the question is, we need our people to have faith in us. Okay,
I
because
think,
my question is, are we suffering from a colonial mindset still that we still undervalue what we have? And we don't recognize the value of what we can do here. But we believe that, others can do it better than us. Now, I've seen that happening. Okay, even within our court system, we pay lots of money to foreign trainers to bring them here to train our people. Whereas we have a pool of trainers here who are equally capable, who can do the job effectively. Now, why is this obsession with others? I don't know. Okay, that's something that we need to deeply introspect, perhaps do some soul searching, and see whether we can, encourage our institutions, promote our institutions, encourage our institutions, and use our institutions. And tell us if you're making any mistakes, if supposing there's any lacuna, we'll correct it. Okay, we'll set it right. It's a process. It's a process of growing stronger and stronger day by day, and for which without support, we can't do it. We need support not just from the government, not just from the judiciary, but also from the stakeholders, from the lawyer community. So unless and until we do that, how are we going to create that ecosystem of dispute resolution that would be competing with anything else in the world? And how do we attract other people to come and use our services here? So this has to be a very consolidated, a combined effort. I think Justice Hemant Gupta also pointed out the same thing. And I completely agree with him on that. Everybody who is watching this, everybody who is a part of the dispute resolution ecosystem need to understand this and need to work together to promote this.
yeah, definitely. I would also like to understand a bit more about mediation, but before I go there, I'm just curious about one point about how institutions approach certain cases, because you had mentioned MSMEs, right? And also we have contracts, because we're talking about foreign seats. We have multiple contracts with multiple parties in complex disputes. So is there a difference or unique tool or approach in approaching a simple dispute, or when of course swift resolution is important for everybody, but even more so for smaller disputes versus complex disputes? Is there a difference in how it is approached or handled?
I think the first approach is to first ask the question, what does the client want? Does the client want a quick resolution of the dispute and to be able to continue with the business? Or does the client want to fight a case for 10 or 15 years and then find his or her name written down in law journals to be read maybe 100 years later by law students, or to be cited as a precedent? So what does the client want? The client wants a solution to the problem, right? Now, invariably, you'll find that most dispute resolution clauses have something like this, that the parties will negotiate in good faith and try to resolve the differences. And if that fails, they'll go for arbitration. Now, the challenge with negotiations is not everybody is an expert negotiator. And when you have a dispute, you are angry with each other. You're not looking at the positive side of things. Okay, you're seeing the other person as a crook, as a person who's out to get you. So negotiations can be difficult because you don't have a clarity about what your real interests are. Now, instead of having that negotiation, supposing you have a mediation clause over there, which says that you will first try to resolve the dispute through the mediation process. Now, you have a time frame for that. You have a window for that, okay? You have a time frame saying that within 3 months, let's say, that the mediation process should be completed. Now, if you have a pool of professional mediators attached to institutions who can do the mediation on a day-to-day basis, And if you have a pool of professional mediation advocates who can assist you, who can navigate you through the process, who know how the process works, not people who are simply trained in the adversarial method, but people who are trained in the collaborative problem solving method. So if they assist you, in all probability, you will be resolving your disagreement within 3 months, or maybe even within 6 months. Ultimately, it's party autonomy. You decide if the process is going on well, you may very well extend the time, right? If you're seeing some positive things coming out of it. Now, what happens? You have your dispute settled. You don't even have to go for arbitration. So that's the biggest advantage, because when you see that there's it makes more sense to settle this rather than to fight it. Okay, just as Hemant Gupta mentioned about execution of arbitral awards, which is a big challenge. Execution of court decrees also. And he pointed out that the problems of the decree holder start from the day the decree is obtained, not till he obtains the decree. Same thing with the arbitral award also. So if you try this, then what happens is you have your dispute settled within that time frame. You have a settlement agreement which has the force of a decree of the court, and if and when the mediation act gets implemented. Otherwise, at best, it is still a arbitral award on agreed terms, right? So you have that with you, right? And invariably, when you have gone through the process, the question of execution doesn't arise, because normally parties invariably comply with what they have agreed to, because they have agreed to it after evaluating all the pros and cons. Now, supposing you're not able to settle, but what the process of mediation does to you is that it gives you much more clarity on where you stand. Which of your claims are really sustainable, which may not really go through. It helps you to have a reality check of what you're claiming. So what happens when you go for arbitration? It substantially narrows the scope of the arbitration also. It gives you much more clarity on what is going to be your stand in the arbitration. So when you go through the process of arbitration, it is much quicker, much more efficient, and you have much more clarity on what exactly you're seeking. Okay. So the unpredictability that is usually there. Now, I'll just give you one example, if you permit me to. I was referred an arbitration which was pending before a former Supreme Court judge. He referred it to me for conducting the mediation. Now, I conducted the mediation. There was an offer on the table for 5 crores. Excuse me, I have a bad cold. So there was an offer on the table for 5 crores. The claim was 45 crores. So the claimant naturally laughed. They said, "What is this? We can't accept it." They went back. Now, in the arbitration, the award that they got was for 4 crores. So you see the unpredictability of any adjudication that can happen. You go to the court making a certain claim, but you may not get that. You may not get what you need. You may not even get what you want. So mediation gives you much more clarity. So this is where at the IAMC, we are very strongly pushing for this. And hopefully that recognition comes, because the stakeholders stand to gain much more by adopting these MEDAB clauses, or even ARB-MEDAB clause. Because, for example, if you take the SIAC, the Singapore International Arbitration Center, and the SIMC, Singapore International Mediation Center, they have an ARB-MEDAB protocol. So what happens is an arbitrator is appointed. The parties go for mediation. So there is a tribunal on standby. So you're not going to be wasting time if the mediation fails. So if there is a settlement, it comes before the arbitrator passes an award in terms of the settlement. So you're absolutely cutting short the whole process of arbitration, and you're getting an award. Now, if that fails, if the mediation fails, you come back for arbitration without losing any time. So the process moves seamlessly from arbitration to mediation and back to arbitration. So this is what we are trying to push. And we are only hoping that not only the clients, but the lawyers understand the advantages of this first. Okay. And if, as a lawyer, if you're putting your client's interest, you will be advising your client to go for this. There's no other reason why you should not advise your client to go for this.
I'm just curious to understand, because I can see how MEDAB or these specific clauses can really help, or this approach can really help in solving disputes, as opposed to, just having very generic negotiation plus ad hoc arbitration clauses, right? But in your experience, when parties do come to settle, do you see that they're already ready to settle, or does it only happen through the process,
No,
as in during the mediation process? Because a lot of times mediation, like you said, even now there is a high, incidence of people going for arbitration in the weekends, and for arbitration to happen after years of litigation and finally settle. So, what have you seen in your experience, sir?
No, see, first of all, one of the advantages of institutional mediation is parties are choosing mediation consciously, which means they recognize the fact that they have to go through this process of what is mediation after all? It is facilitated negotiation. You have a neutral facilitator who helps you to see each other's point of view, to maybe do a reality check of what your expectations are, and see what your real interests are and how would you like to see the whole problem resolved. So that's the job of the mediator. So when a mediator is able to effectively do it, now when you come for the arbitration, you may not be having a clear idea of what exactly you're going to get out of it, where it is going to go, but the process helps you to get much more clarity, right? So you're able to recognize what your real interests are and what will help you to move forward. So you're able to make a very practical assessment of where you stand and what you need. And you're able to reach an agreement that is something which would be sustainable, that's not going to be challenged anywhere because it's a mutual agreement, right? It's not something that the mediator is imposing, unlike an arbitrator. So there is going to be compliance with that. And there is a possibility that your relationship might be saved for the future. So this will help you to, and definitely the presence of a mediator helps to bridge the gap between the two parties. The communication gap, the negotiation gap that is there, because the mediator brings to the table those communication and negotiation skills that parties may not be having themselves. Okay. So once they go through the process, they get much more clarity. So even though when they come for the mediation, they may not have that idea as to how this is going to be resolved, or they may even feel very strongly that this is not at all a fit case where we need to go through mediation. But if you can spend that short period of time in trying to work towards a solution, it gives you the clarity. At worst, you get the clarity. At best, you get a settlement. So either both these things work to your advantage, right? And it definitely cuts short the process. The simple question is, the question may be asked, why should I, when I know that it may or may not settle in a mediation, why should I go for mediation? Why can't I straight away go for arbitration? Now, if I have a stomach ache and I have the option of taking some medication and trying to see whether it's going to get settled with that, would I go for a surgery? So would I not mind spending that small amount of money that I need to spend on getting the medication and trying to see whether that can cure me before I go for the surgery? So it's common sense. I mean, it makes a lot of commercial sense also, right? Because
Definitely.
ultimately
Are
what you're
there
going to be spending in the arbitration and it's a gamble ultimately. Okay, it's a gamble. Whether you're going to recover really what you're, even if you get what you want, asking for, how are you going to recover it? That's another challenge for you, right?
Um, are there any, because you were talking about, getting the clarity or a resolution in the process, are there any particular kinds of disputes that you see are best suited for mediation? Because usually mediation is seen probably like personal disputes. So when it comes to the commercial context specifically, also, is there anything that you see
That is,
most suited for mediation?
that's the tragedy of mediation in India
Yeah,
because, it started as court annexed mediation, right? And it got the traction, it got the exposure, it got the awareness was created thanks to the court annexed mediation program. But the flip side of that is it somehow got to be known as fit for only family cases, for matrimonial
exactly.
disputes, for child custody cases, for small partition disputes. No, I'm sorry. There's no limit for mediation. Anything can be negotiated and settled, can be mediated and settled. Whether it is a family dispute involving the custody of a child or fixing of alimony, up to a commercial dispute that involves several hundred crores or thousand crores. It can all be mediated. There's no such thing as something that cannot be mediated. Anything that can be mediated and settled, can be negotiated and settled between the parties, which the law permits, can be mediated and settled. Unless there's an embargo under the law, there's nothing that stops you from going in for mediation. So I don't see mediation being limited by anything. And you know, one factor is, of course, the association, because it started off as a pro bono part-time practice. I would call it as a pro bono part-time avocation. It started off. But what it needs to evolve into today, and what it is evolving into today, is a full-time profession. Okay, and that's what is happening abroad. Now, I was talking to Mr. George Lim, who is the chairman of SIMC. I said, let's have a joint protocol between IAMC and SIMC for mediations. He said, how do we have it? You don't do full-day mediations. We do full-day mediations. And that struck me. I thought, we really don't do full-time mediations. We do it only part-time. And we always regard it as pro bono. I hear speaker after speaker in various seminars and conferences saying it's good for community disputes, for family disputes. Nobody talks about disputes. Large-scale commercial disputes. Because which commercial sector person, or any CEO or any managing director or any person who's handling a multi-crore dispute would like to fight for years together and not know whether he or she is going to get the returns for that.
If I may, sorry to interrupt, just one question, because you were, just to drive this point home, without going into confidential details, could you share an example of any dispute you've handled or seen where mediation particularly worked well, and why, in case of a commercial dispute?
See, there was a commercial dispute where a contract was entered into for constructing a very specialized building. Both were very big companies. Okay. And what happened was there were a lot of issues that came up in the execution of the contract. So the contractor left the work unfinished and went away. So the employer company terminated the contract, adjusted all the deposits, and got the contract executed through another contract. Now the contractor comes back and claims 8.5 crores from the employer company. So that is referred for mediation. And in the mediation, the employer company says that after adjusting all the amounts, we have about 25 lakhs which we can offer to them. That's the only thing we can pay them. Now, when I go back to the contractor company, I asked the contractor company, can you help me to understand what this 8.5 crores is all about? And after a brief discussion, they say that realistically, what we want is our amount of 1.5 crores, which is our deposit with them. If they give us that, we are willing to close it. Now I see what we call in mediation language as the ZOPA, the zone of possible agreement. And I go back to the employer and I ask the employer, if they are willing to come down, what are you willing to do? They said, we are willing to go up a little, right? So at one point of time, remember one thing, 25 lakhs, 8.5 crores. This is the margin. Now I brought them together, okay? And at a point where I felt they were comfortable with each other, they could see the effort that each one was putting into finding a settlement for this. And ultimately, it got settled for 66.5 lakhs. Okay, so this is a classic case where, but for the fact, I'm not saying because I was the mediator, but I'm saying, but for the fact that there was a mediator there, that discussion would have collapsed 1,000 times. There were 1,000 times when the parties wanted to walk away from the table, and the mediator brought them back together. Okay, different techniques for the negotiation were used by the mediator. So this could help them to bridge that gap and come to a settlement, because they came to a point where they were able to see the effort that each one was putting into trying to resolve the matter. And they saw the value of a future relationship between them, because both were very big companies, specialists in their respective fields. And they saw the value of a future relationship, right? So they were able to settle it. So this is where I feel that mediation works. I have seen it firsthand, it works. Okay, Chitra and I were mediating a dispute between a US company and an Indian company. And we were able to reach a settlement there. Okay, but for the fact that the mediators were there, it would not have settled. If they were directly negotiating, it would have collapsed, because they were not able to see each other's perspective. But the mediators were able to bring them to a place where they were able to settle with each other. Okay, so this is where the value of mediation comes, and the value of trained mediators comes. And that's where the quality of training also becomes very important, because we have this fixation about 40 hours training. Whenever I conduct the 40 hours training, I tell my trainees that this is your starting point. You're not mediators yet. You're on the journey to become mediators. So there's a lot more that you have to go through. So what we are trying to do at the IAMC is we are trying to restructure this training. We are trying to reimagine the whole curriculum and make it really comprehensive enough that when you finish the training and come out, you're really a qualified mediator who's capable of mediating any kind of dispute.
Yeah, thank you. I think that example also really helped to, emphasize this point and actually create awareness on the fact that, mediation is probably better suited for tense commercial disputes because they are collaborative nature as opposed to litigating adversarial system where it's against. I mean, it just probably sometimes exaggerates the issues, and this is yeah.
I'll just add one more thing, Aishwarya. Let's take some big boardroom disputes, okay, between the board of directors, especially in family-held companies, okay, very high-value companies. The boardroom disputes can lead to the destruction of the whole company if they go for litigation. And that is where, the mediation process can help them to bridge that gap to come to a settlement so that the company survives and they're able to continue with the business. So there are multiple spaces where mediation can play a very significant role in resolving the disputes, and for which we need to create that ecosystem, and we need to professionalize the whole thing. Okay, there's no point in talking about anything unless we have that clear policy of professionalizing it and institutionalizing it.
Definitely. I think that was going to be something I wanted to ask you about because we've been speaking for most of the beginning of the session about institutional arbitration. So how do you see institutional mediation evolving? And because that's where we need to set up that ecosystem as well as being available. So how do you see that evolving?
See, I see institutional mediation evolving in the sense that it will give the space for individual mediators to not only get trained, but also to get the kind of work that they really need to get. Because there are some limitations in the court annexed mediation. Because, for example, you have a qualification criteria that you have to finish 10 years or 15 years of practice. Whereas and you have to be a lawyer to get trained. Whereas here in the institutional framework, we are looking at sector specialization. We have trained insolvency professionals in mediation. We have trained engineers in mediation, chartered engineers in mediation. We have trained architects in mediation. So they all bring their sector expertise into the process. And this is where the professionalization can really happen. Because when you have sector specific specialization, then that gives a different quality to the whole process itself. And that really professionalizes the whole thing. So you have professional mediators now who are willing to come and sit in the morning and continue the mediation till the evening. They don't come at 4:30 in the evening and sit and do the mediation after the court hours, where in the till 4:30 or 5 o'clock you're wearing the adversarial hat, you're fighting tooth and nail. Okay, you're clawing and gnawing at each other. Now you come and suddenly you're expected to be collaborator. How does that happen? That's what made me give up litigation completely and come into mediation, because I realized I can't wear those two hats. Right?
That's lovely. Thank you. That really does help. In focusing on that as the mainstream as opposed to an afterthought. Before we take, because there are some questions from the audience, but before we move, I have one last question as a takeaway. You've spent decades building and teaching area systems, and if we look ahead 10 years, what do you think will distinguish institutions that succeed versus those that remain underutilized, both arbitration and mediation?
I think the most important thing will be the policy of creating institutions that that can work without really depending on the revenue as such to sustain themselves. Okay, that's where the government support is needed. The second thing would be to ensure that the standards are maintained, that the integrity is maintained, the credibility should be there, for which supervision is important. So supervision of the institutions. Like, for example, in IAMC, we have a board of trustees consisting of 2 life trustees who are the former judges of the Supreme Court. We have the ex officio trustees as the Chief Justice of Telangana and the Chief Minister himself, who's the law minister also. So both of them are ex officio trustees. We have a governing council, we have term trustees. Now they supervise. They don't control. The institution functions in total autonomy. There's absolutely no interference from any quarter. So judicial supervision should be there, but not judicial control over the institutions. The third thing is the judiciary needs to develop faith in institutions. You cannot keep suspecting everybody. You cannot keep thinking that everybody is without integrity, without credibility, right? You have to start trusting, okay? And you have to start referring cases to institutions, okay? And you have to set up those kind of institutions that have the framework, the infrastructure, because the infrastructure is very important. The whole experience of going through a dispute resolution mechanism depends on the kind of infrastructure and the logistical support that is provided by the institutions. So that's something very critical, right? So unless and until we have this kind of an ecosystem, which is policy driven, which is autonomous, which is credible, which is efficient, that is how I see the future. That is one part of it. But having such institutions alone is not enough if we don't have trained professionals. And I'm not just talking about the neutrals being trained, either as arbitrators or as mediators. I'm talking about lawyers being trained. Because today, a law school curriculum trains you to be an adversarial, to be a gladiator. Okay. And I was speaking in a webinar recently where I said that the transformation of the opposite party in the mind of your client, from a rascal, it becomes a bloody rascal when he comes to our office. Because we have to bring it. It's not our fault. It's the way we have been trained. I'm not blaming lawyers at all. The law school curriculum needs to be seriously looked at. And lawyers have to be trained as problem solvers and not problem inflamers. Okay, so that mindset change has to happen. There has to be a paradigm shift in the way we approach dispute resolution. It should not be looked at from the prism of justice delivery. It should be looked at from the prism of problem solving. Because when you talk about justice delivery, it operates on a fault-finding paradigm. You have to find fault with your other party in order to succeed in the court. Whereas you have to look at it from a problem-solving approach. The whole shift has to happen there. I'll stop there. I think Madhav has warned us that we are running out of time.
Yeah. Just one takeaway I see that, a common theme that's come through all your topics is that unfortunately, while on the one hand, we do have evolving landscapes where institutions are available, professionals are available, I think the shift is critical in terms of cultural mind shift and working together as an ecosystem. So with that, I think I will go to questions from the audience. I have Amuda from VIT. She asks, sir, your view on retired judges dominating the arbitration as arbitrators, and whether this stands as a hurdle for India as a whole to become an international excellence center in arbitration.
See, I don't see any problem at all in retired judges being appointed as arbitrators. But all I am saying is that it cannot be through the ad hoc process of appointments. I think even retired judges should get empaneled with institutions, be bound by the rules and regulations of the institutions, accept the fee structure of the institutions, and agree to abide by the timelines that are prescribed by the institutions. So they bring a lot of expertise, they bring a lot of knowledge, right? They bring a lot of experience. So there is no point in letting go of all that by saying that they are monopolizing. Today, yes, that is the situation. But if that situation changes, there can be a lot of positive contribution from the retired judges because they bring so much of experience to the table, right? And one of the important things is, I feel personally, is that sector-specific training becomes very important. So even the retired judges can choose in which sector they want to specialize in because they come from a practice background. So some judges might have practiced as commercial lawyers. Some judges might have specialized in real estate and construction disputes. Some judges may have specialized in intellectual property disputes. So let them choose the specialization so that they can, when the appointment issue comes, they will naturally be chosen considering not only their legal experience, but also the judicial experience. They can easily be chosen as the arbitrators. Now, that is something that the parties should choose. It should be left to the preference of the parties. Now, what happens in the ad hoc arbitration is that opportunity is denied to the parties. Because in ad hoc arbitration, the court chooses the arbitrators. And there is no, with due respect, I feel there's no focus on what is the specialization of a particular judge to be appointed as an arbitrator in that particular case. And there's no requirement for updating with the latest developments. And there is no, restriction on the fees. There's no restriction on the timelines. So these are things I think that the institutional framework will help to resolve. And that means a lot for the stakeholders, for the real stakeholders who are affected parties, because they are spending their money, they're losing. And look at the ultimate impact. It's impacting the economy. Just to share some information here, which I read in the Business Standard, it says that the pendency is amounting to almost 1.5% of the GDP loss. There's a loss in terms of GDP that's impacting the economy of the country. It's driving away foreign investments. It is making people lose faith in our justice delivery system, in our dispute resolution ecosystem. So for all this, I think we need to, we need to understand the larger goal that is there. Okay, the larger interests of the nation have to be kept in mind before we look at our own interests. And that is where I think the collaboration between the judiciary, the government, the stakeholders, the chambers of commerce, the businesses, the institutions has to work together. That collaboration is important.
I think I'll just take one more question and then we'll break before the next session. Bindu from Origin asks, how do you see the role of mediation in IPR, more specifically patent law?
See, patent law, that's a bit, that will take some time if you're answering the question, because see, patent is basically you get a patent, right? You have you have a patent under the law, right? You have a license. Now, there might be disputes that might come up in terms of the infringement, in terms of the right to use, conferring the right to use. Now, those are all areas where mediation is possible, because that's where the distinction between a right in rem and a right in personam comes. Because even rights in rem have certain issues that come up, which are basically rights in personam that can be negotiated and settled. So even in patent law, wherever there is a scope for negotiation and resolution, there's a scope for mediation and resolution. That's how I look at it. So that's my very brief answer for that.
Thank you. Thank you so much, Mr. Jawad, for those overall insights on institutional frameworks that are shaping a dispute resolution in India, and for very actionable takeaways. I think that would have really helped our audience today. In our next session, we will take this discussion a step further and explore how technology, that's something you had briefly highlighted, that will be explored in depth, about how technology and ODR platforms are beginning to influence arbitration and mediation processes. But before that, we will take a much needed short break, I think, for you and for the audience. And then it'll be over to Chitra to the panel discussion.
Thank you, Aishwarya. Thank you, JustAct. Aishwarya, your questions were really good. And JustAct, thank you for this opportunity.
Thank you so much.